Hi, my name is Michael Hollins, and I am the managing attorney here at Hollins Bankruptcy Law Office, where we practice bankruptcy law. And today's topic is how to use Chapter 7 bankruptcy to stop a wage garnishment. But before I get into the topic, if you need any additional information regarding bankruptcy, please head on over to hollinsbankruptcy.com, or you can reach out to us at 866-86-BILLS. That's 866-862-4557. And you can set up an appointment to talk with an attorney for free about your situation. Now, on to the topic, how to use Chapter 7 bankruptcy to stop a wage garnishment. Now, if your wages are being garnished, or if you fear that they will soon be garnished due to maybe a pending lawsuit, then just know that filing for Chapter 7 bankruptcy will stop the garnishment in most cases. Now, you may hear the term wage attachment. That is synonymous with garnishment. Now, this happens because bankruptcy gives you protection as soon as you file called an automatic stay, which prohibits your creditors or the people you owe from continuing to attempt to collect from you during the pendency of the collection case. So that garnishment that we spoke about with the automatic stay in place has to stop, along with any other harassing phone calls or other collection efforts. Now, what is a wage garnishment? Most creditors cannot garnish or take money out of your check without first suing you in court and getting a money judgment. And that's how a wage garnishment starts, is with a lawsuit. Now, there are a few exceptions to this. For instance, student loans, taxes, or child support. They don't need to go to court and sue you. They can go straight to the garnishment piece and begin to pull money from your check. But in most cases, including credit card balances, medical bills, personal loans, payday loans, other lawsuits that you may be liable for monies, that creditor must actually file a lawsuit and they must win. Now, once the creditor has won, they will receive a money judgment saying basically how much you are liable for or how much you owe. And that money judgment is what they use to get an order to garnish your wages from the court. Now, the sheriff or the clerk typically will send that wage order or the wage attachment or that garnishment order to your employer, who then begins to withhold money from your check every pay period to send money to that creditor. Now, there are limits as to how much the employers can pull from your check, but in most cases, it is about 25%. And that 25% per check can make a big difference in paying your bills and your responsibilities. Now, what happens when you file Chapter 7? When you file Chapter 7, again, the law immediately begins to protect you from those creditors by imposing an automatic stay. That stay prohibits the creditors from taking that action that I spoke of earlier, including the wage garnishment. Now, because the wage garnishment is a collection effort, it is the main collection effort that we're talking about here today. I'm just going to focus in on that. But you should know that that automatic stay also stops the harassing phone calls, the emails or texts that you may get from creditors. It'll stop the mail that comes to the house from any lawsuits. It stops those things as well. But most notably, what it won't stop, again, is child support, taxes, those things it absolutely will not stop the collection efforts on. Now, a creditor can still go to the bankruptcy court and ask the court to lift the automatic stay. However, the court is really reluctant to do that in most situations. The process of the bankruptcy has to play out, and that is what Congress intended. So in order for a stay to be lifted, in a lot of cases, the creditor must have a secured asset that they feel maybe would be harmed if it were to stay in the possession of the debtor, like a house or a car. If you didn't have insurance on a vehicle, or if you didn't have homeowners insurance, then a creditor may make the case that they need to remove those items from you. That is one situation in which that could happen. If a creditor feels that they will lose more money based on an asset being in your possession, then they may make the case as well. But please let me reiterate that as soon as you file for the purposes of this conversation, the wage garnishment must stop and the creditor must go to the court and petition the court to do anything different than other than stopping the wage garnishment. Now, how will your employer know that you filed bankruptcy and that the wage garnishment is to stop? Well, simple. When you file the information that you give to myself, when you give to the attorney, we send to the court, and the court is directed to send a stop order to your payroll department or to your employer. Your employer then, based on the internal mechanics of the accounting department, that order should make its way to the payroll folks, and they should stop the wage garnishment. And that is an automatic process. Again, as soon as you file, that happens. Now, what happens to the bankruptcy, or what happens to the garnishment when your bankruptcy case ends, which is really important because at the end of your bankruptcy case, the goal is to get a discharge of all of your debt. Now, if the garnishment was from some of the sources that I mentioned earlier, your unsecured debt, such as a credit card, medical bill, a loan, a payday loan, a lawsuit of sorts, then chances are that debt will be discharged, meaning that not only did the garnishment stop, but those debts are discharged and you don't have to pay those back. So the Chapter 7, in essence, will not only stop the garnishment, but it will wipe out the debt and give you the fresh start that you all hear me talk about all of the time. It's a great tool if you find yourself in this situation where a creditor is pulling 25% of your check and you find it hard to pay your necessary bills. You definitely want to look into Chapter 7 bankruptcy as your solution. Well, I hope you found this information helpful. I hope that you would please give this a thumbs up if you did, if you found some utility in the video. I ask that you please share the video. You just don't know who may need this information that you know. And also, if you would like to have more conversation with me, with an attorney, please give us a call at 866-86-BILLS, or you can head on over to hollandsbankruptcy.com where you can set up an appointment to talk with me at a time that is convenient for you. I would like to thank you as always for listening, and please be safe.